A Queen's Counsel, or King's Counsel during the reign of a king, is an eminent lawyer, who obtained an extreme reputation and is appointed by the Queen on the suggestion of the Lord Chancellor to be one of Her Majesty's Council. Learned in the law, the term is also recognized as an honorific. Membership exists in various Commonwealth jurisdictions around the world, while in some other jurisdictions the name has been replaced by one without monarchical connotations, such as senior counsel or senior advocate. Queen's Counsel is a status conferred by the Crown that is recognized by courts. Members have the privilege of sitting within the bar of court. As members wear silk gowns of a particular design, the award of Queen's Counsel is known informally as taking silk, and hence QCs are often colloquially called silks. Appointments are made from within the legal profession on the basis of merit rather than a particular level of experience. However, successful applicants tend to be barristers, or advocates, or solicitor advocates with 15 years of experience or more. History. England and Wales. Historical background. The Attorney General, Solicitor General, and King's Sergeants were King's Counsel in ordinary in the Kingdom of England. The first Queen's Counsel Extraordinary was Sir Francis Bacon, who was given a patent giving him precedence at the bar in 1597, and formally styled King's Counsel in 1603. The new rank of King's Counsel contributed to the gradual obsolescence of the formerly more senior Sergeant at Law by superseding it. The Attorney General and Solicitor General had similarly succeeded the King's Sergeants as leaders of the bar in Tudor times, though not technically senior until 1623 and 1813 respectively. But the King's Counsel emerged into eminence only in the early 1830s, prior to when they were relatively few in number. It became the standard means to recognize a barrister as a senior member of the profession, and the numbers multiplied accordingly. It became of greater professional importance to become a KC, and the sergeants gradually declined. The KCs inherited the prestige of the sergeants and the priority before the courts. The earliest English law list, published in 1775, lists 165 members of the bar, of whom 14 were King's Counsel, a proportion of about 8.5%. As of 2010, roughly the same proportion existed, though the number of barristers had increased to about 12,250 in independent practice. In 1839, the number of Queen's Counsel was 70. In 1882, the number of Queen's Counsel was 187. The list of Queen's Counsel in the Law List of 1897 gave the names of 238, of whom hardly one-third appeared to be in actual practice. In 1959, the number of practicing Queen's Counsel was 181. In each of the 5 years up to 1970, the number of practicing Queen's Counsel was 208, 209, 221, 236 and 262, respectively. In each of the years 1973 to 1978, the number of practicing Queen's Counsel was 329, 345, 370, 372, 384 and 404, respectively. In 1989, the number of practicing Queen's Counsel was 601. In each of the years 1991 to 2000, the number of practicing Queen's Counsel was 736, 760, 797, 845, 891, 925, 974, 1006, 1043, and 1072, respectively. The title traditionally depends on the sex of the sovereign. The current Queen, Elizabeth II, has had a long reign, and few if any people appointed as King's Counsel survive. It can be assumed that, should the Queen die and the title pass to a descendant, the title will again become KC, as the next three in line to the throne are male heirs. Restrictions on Queen's Counsel. Queen's Counsel and sergeants were prohibited, at least from the mid-19th century, from drafting pleadings alone. A junior barrister had to be retained. They were not permitted to appear in court without a junior barrister, and they had to have chambers in London. For the beginning, they were not allowed to appear against the Crown without a special license, but this was generally given as a formality. This stipulation was particularly important in criminal cases, which were mostly brought in the name of the Crown. The result was that, until 1920 in England and Wales, King's and Queen's Counsel had to have a license to appear in criminal cases for the defense. These restrictions had a number of consequences. They made the taking of silk something of a professional risk, because the appointment abolished at a stroke some of the staple work of the junior barrister. They made the use of leading counsel more expensive, and therefore ensured that they were retained only in more important cases, and they protected the work of the junior bar, which could not be excluded by the retention of leading counsel. By the end of the 20th century, however, all of these rules had been abolished one by one. Appointment as QC is now a matter of status and prestige only, with no formal disadvantages. Modern reforms. Queen's Counsel were traditionally selected from barristers, rather than from lawyers in general, because they were counsel appointed to conduct court work on behalf of the Crown. Although the limitations on private instruction were gradually relaxed, QCs continued to be selected from barristers, who had the sole right of audience in the higher courts. The first woman appointed King's Counsel was Helen Kinnear in Canada in 1934. The first women to be appointed as King's Counsel in the United Kingdom were Helena Normanton and Rose Heilbronn in 1949. Recent developments in the United Kingdom. England and Wales. In 1994, solicitors of England and Wales became entitled to gain rights of audience in the higher courts, and some 275 were so entitled in 1995. In 1995, these solicitors alone became entitled to apply for appointment as Queen's Counsel, and the first two solicitors were appointed on the 27th of March 1997, out of 68 new QCs. These were Arthur Marriott, partner of the London office of the American law firm of Wilmer Cutler and Pickering based in Washington, D.C., and Lawrence Collins, a partner of the city law firm of Herbert Smith. The latter QC was subsequently appointed as a High Court judge and ultimately Justice of the Supreme Court of the United Kingdom. The appointment of new Queen's Counsel was suspended in 2003, and it was widely expected that the system would be abolished. However, a vigorous campaign was mounted in defense of the system. Supporters included those who considered it as an independent indication of excellence of value to those who did not have much else to go on, and those who contended that it was a means whereby the most able barristers from ethnic minorities could advance and overcome prejudice, as well as better represent members of an increasingly diverse society. The government's focus switched from abolition to reform and, in particular, reform of the much criticized secret soundings of judges and other establishment legal figures upon which the old system was based. This was held to be inappropriate and unfair given the size of the modern profession, as well as a possible source of improper government patronage, and discriminatory against part-time workers and ethnic minorities. In November December 2004, after much public debate in favour of and against retaining the title. The government announced that appointments of Queen's Counsel in England would be resumed, but that future appointees would be chosen not by the government but by a 9-member panel, chaired by a layperson, to include 2 barristers, 2 solicitors, 1 retired judge, and 3 non-lawyers. Formally, the appointment remains a royal one made on the advice of the Lord Chancellor, but she no longer comments on individual applications. The Lord Chancellor supervises the process and reviews the panel's recommendations in general terms. Application forms under the new system were released in July 2005, and the appointment of 175 new Queen's Counsel was announced on the 20th of July 2006. A total of 443 people had applied. Of the 175 appointed, 33 were women, 10 were ethnic minorities, and 4 were solicitors. 6 people were also appointed QC honoris causa. On the 16th of October 2006, a couple of weeks after the beginning of the legal year, the successful candidates made a declaration and received the letters patent from the Lord Chancellor in Westminster Hall. Further appointments were announced on the 22nd of January 2008 and the 23rd of February 2010. The process takes place annually, with the last appointments to date announced on the 19th of February 2014. Further information can be found at the Queen's Counsel Appointments website. Northern Ireland. The title of QC continues to be used. In 1998, 2 Northern Ireland barristers opposed the requirement of swearing an oath of allegiance to the Crown. The Bar Council, the body which represents barristers' interests, had agreed that the royal oath should be dropped and replaced by a more neutral statement. It suggested that, instead of declaring services to Queen Elizabeth, barristers should sincerely promise and declare that I will well and truly serve all whom I may lawfully be called to serve in the office of one of Her Majesty's Council, learned in the law according to the best of my skill and understanding. In 2000, the Northern Ireland High Court ruled in the barristers' favour. After more wrangling, the barristers were permitted to make a more neutral statement of commitment to principles. In 1997, the Lord Chief Justice, Sir Robert Carswell, wrote, "I have little doubt myself that this is all part of an ongoing politically based campaign to have the office of Queen's Counsel replaced by a rank entitled Senior Counsel, or something to that effect." Scotland. The independent bar is organised as the Faculty of Advocates, and its members are known not as barristers but as advocates. The position of Queen's Counsel was not recognised before 1868. Initially the status was reserved first for law offices and soon after for the Dean of the Faculty of Advocates. In 1897 a petition by the Faculty of Advocates for the establishment of a Scottish roll of Queen's Counsel was approved, and the first appointments were made later in that year. In 2005 there were more than 150 QCs in Scotland. The appointment of Queen's Counsel is made on the recommendation of the Lord Justice General to the First Minister of Scotland, formerly the Secretary of State for Scotland. In the 1990s, rules were changed so that solicitors with rights of audience in the Court of Session, a High Court of Justiciary, were permitted to apply for appointment, and 2 or 3 have done so. A solicitor advocate who is so appointed is correctly designated as Queen's Counsel. Solicitor advocate. Countries or territories that have abolished the Queen's Counsel designation, In jurisdictions that have become republics, the office of Queen's Counsel has sometimes been replaced with an equivalent, for example, Senior Counsel in South Africa, Kenya, Trinidad and Tobago and Guyana, Senior Advocate in Nigeria, India and Bangladesh, and President's Counsel in Sri Lanka. Hong Kong. In Hong Kong, the rank of Queen's Counsel was granted when it was a Crown colony and British dependent territory. A practicing barrister could be appointed as Queen's Counsel in recognition of his or her professional eminence by Crown patent on the advice of the Chief Justice of the Supreme Court of Hong Kong. As Hong Kong severed ties with the United Kingdom in 1997, barristers are no longer appointed Queen's Counsel, but as Senior Counsel. Those appointed before the change were renamed Senior Counsel. Nigeria replaced the QC nomenclature with the new title of Senior Advocate of Nigeria. Appointments are restricted to fewer than 30 lawyers a year, made by the Chief Justice of Nigeria on the recommendation of the Legal Practitioners Privileges Committee, which is made up of senior judges and lawyers. The qualification requirements are almost identical to those required for appointment as Queen's Counsel. The Sands are entitled to wear silk gowns and enjoy similar privileges as the Queen's Counsel. Sri Lanka. President's Counsel is a professional rank, as the status is conferred by the President, recognized by the courts, and wear silk gowns of a special design. It is the equivalent of the rank of Queen's Counsel in the United Kingdom, which was used in Ceylon until 1972 when Sri Lanka became a republic, when the position became that of Senior Attorney at Law. In 1984 the position became the President's Counsel. The holder can use the post-nominal letters PC after his or her name. Zambia. In Zambia the designation was changed to State Counsel after independence from Britain. Legal practitioners who enjoy the rank and dignity of State Counsel may use SC after the names. They enjoy preeminence before all courts in which counsel's appearance is permitted. The procedure for appointment is more or less based on the English system. In recent times, however, the merit-based system that had held for so long seems to have been replaced by political patronage. While the Legal Practitioners Act requires that those that seek this position either apply, but the Law Association of Zambia recommends their names for appointment. The last 3 presidents have taken it upon themselves to appoint those who are mainly the supporters within the profession to the position of State Counsel. This has created unease in the profession and diluted the rank somewhat. Legal profession. For example, when late President Mr. Michael Sata abrogated the clearly laid down procedure for appointment of State Counsel by appointing Mumba Kapumpa, John Sangwa and Robert Simeza as SC, the Law Association of Zambia reacted with dismay. In a statement made available to the Daily Nation, a local daily, and published on the 11th of May 2013, the association's Vice President Ms. Kasond said that the procedure for the appointment of any lawyer to the position of State Counsel must be considered, adding that conferring anyone the State Counsel rank must be granted on merit and not due to any other considerations. Ms. Kasond said that the Legal Practitioners Act was clear on the appointment of individuals wishing to be conferred with the rank of State Counsel, and therefore, the association would not accept any circumvention from the principle. We wish to draw the attention of members and the general public to the law regarding the appointment of State Counsel. Section 17 of the Legal Practitioners Act provides the procedure for the appointment as follows. 17. Any practitioner wishing the rank and dignity of a State Counsel for Zambia to be conferred upon him shall submit his application, accompanied by the recommendation of 2 State Counsel, in that behalf to the Attorney General, he said. She also said that upon receiving the application of individual wishing to be honored with the position of State Counsel, the Attorney General shall, after consultation with the Chief Justice and the Law Association of Zambia, Zambia, make a recommendation to the President. Quote, on receiving such an application, the Attorney General shall, after consultation with the Chief Justice and the Association, make such recommendation thereon to the President as he thinks fit, and the President may, after taking such recommendation into consideration, in his discretion, either reject the application or, subject to the other provisions of this Act, appoint, by letters patent under the seal of the Republic, the applicant as State Counsel for Zambia, she explained. The recent appointment of the country's Attorney General Lycanda Kalaluka, which entails an automatic conferment of the rank and dignity of State Counsel and title of Leader of the Zambian Bar, which the Law Association of Zambia opposed, is another case in point.